Hey guys, and welcome to the weekly docket. Let's start here in the South, down in the low country of South Carolina. Last we left off, Murdaugh was trying to get an extra $160,000 to help with his appeal legal fees and other expenses. The issue is that would reduce the pot of his assets that is supposed to go to his victims. And he's already taken more than $500,000 for his defense. Well, he lost that request. The judge said no. You made an agreement of how to disperse these funds, you got the amount you agreed on, and you can't change it now. Makes sense, right? That was positive news for attorneys for the victims, and of course the victims, including Eric Bland, who represents the Satterfield family. Now, he's been sparring regularly with Murdaugh's attorneys for a long time, really, and it seems Murdaugh's attorneys aren't going to take this defeat lying down. They filed a Rule 60 motion to have Murdaugh's confession of judgment as to the matter of the Satterfield death vacated. In this motion, they basically say Bland got a confession of judgment that was not factually based, did it to avoid a gag order, and also to stop any action to recoup funds his clients received based on fraud or no facts or whatever. The interesting part is Murdaugh's motion to vacate his confession of judgment is that it's based on basically Murdaugh's own lying. See, Murdaugh's insurance kicked in because of the allegations the dogs tripped Miss Satterfield. Alec Murdaugh is the one who brought the dogs into the case, talking about them, no one else. And because that created a basis for the insurance claim, it allowed him to eventually get and steal the insurance money. Later, he gave a confession of judgment to Satterfield's attorneys, basically saying, yeah, I'm liable to you for how, I ran the household or whatever, the dogs. So here's why it matters now. If the confession of judgment is vacated, it's possible in theory for other parties to say the insurance money was wrongfully received by the Satterfields as the coverage was invoked by Murdaugh's fraud, and so try to get the money back. But Murdaugh's not trying to get the money, okay? So why is he filing this motion? The motion basically stands on the idea that we need to set the record straight, and the document doesn't contain all the required information, so it should be void. But most white knightly of all, Murdaugh's concerned that his other victims could be harmed in this whole process. See, if the Satterfield family doesn't have to give the money back, Murdaugh's concern is that they will then turn to the receiver who has Murdaugh's assets and make their own claim for this over $4 million to the receiver saying, hey, we're victims in this too, which they were since Murdaugh stole the money from the insurance companies. So we have a claim in here since we can't get it from these other people. How touching that he would be concerned that the victim's money pool would be reduced at the same time he was trying to get that victim's money pool reduced by another $160,000 so that he could pursue his appeal. Okay. Is there one person on the planet who thinks Murdaugh is motivated in any way by concern for his victims? No. Even an alien, if it traveled here from a distant galaxy, one of its first communications would probably be, I don't trust Murdaugh at all. Another angle is that this is another move, though, in warring sides with Bland on one side and Harpootlian on the other. Hey, Harpootlian says, you helped keep us from getting the $160,000, so take this, Bland. Bland responded in part thusly on the website of his firm. This motion is nothing more than the endless and nonstop prattle of sore-losing lawyers. We welcome addressing these arguments in court. They have lost almost all of the meaningful motions they filed on behalf of their miscreant client, Alex Murdaugh, over the past 2 years. We are confident this most recent motion will be another loser. Yeah, they also lost a little thing called a murder trial, where he was convicted for murdering his family. Now, of course, Bland has the more sympathetic position here, representing as he does victims of Murdaugh's fraud. But he's not running a victim shelter. His job is to zealously represent his clients. So I get Harpootlian as saying Bland gets the confession of judgment, and that's just a maneuver to ensure his clients get a secure pot of dollars. But I mean, if Bland could do that and he didn't do it, what kind of lawyer would he be? It's almost like Harpootlian making an advertisement for Bland's firm, I think. Now, if other victims think this is an issue, they would be the ones, in my opinion, to do something about it because they'd be the ones who aren't getting the money, right? I mean, nobody thinks Murdaugh is the right person to stand up for some of his victims against others. Come on. So when Bland says Murdaugh lacks standing to make these arguments on behalf of the other settling parties, I'm thinking, yeah, I completely agree with this. Poot even says in his own motion that Murdaugh is not harmed at all by this confession of judgment, and that whether it stays or goes, basically, Murdaugh's life would not change in any way. Okay, then why spend the time on this motion then if it doesn't hurt or help Murdaugh, no matter whether it's made, not made, granted, or not granted? It does seem kind of like Bland has a point that it's sour grapes for fighting against the other 160 grand. And I'll have to say, just before I started recording this, I saw that Bland posted up a tweet saying that some of these filings are occurring while Murdaugh and his team are filming a documentary. I don't know if that's true or not, but if it is, you know, this is the timeline of reality we live in, people. Let's get out of South Carolina. Let's go out west, put cowboy hats on, and head up into Idaho, the Kohberger case. That's seen a flurry of activity. Let's start where we left off last week with the media's argument we need to speed up this hearing on the gag order, irreparable harm every day. The judge wrote a really long order that can be summarized thusly. No. In short, she says the topic is important and all sides deserve the normal time to be heard on this, as the issue of public right to know versus fair trial considerations is important, and it should be reviewed after the parties have a chance to marshal their arguments. Kind of hard to argue against that. But the big bombshell is the cancellation of the preliminary hearing. Instead, Kohberger will proceed to trial based on a grand jury indictment. To get this indictment, the grand jury was presented with witnesses and evidence from the prosecution and not the defense, just like every grand jury indictment. And there's no conspiracy here. That's how it works. With the preliminary hearing coming up, I thought maybe the DA had decided not to go via a grand jury. However, they did, and that's not something that just happened yesterday, because that procedure takes quite a long time. So it's been moving for a while. Now, this is my own fault, but I've looked at and seen some comments about, oh my God, how could he be arrested without an indictment? It's just shady. It's a conspiracy. You know, Kohberger is getting love letters in jail like Murdaugh, and I think those people must be all over social media making these kind of dumb arguments and statements. I mean, imagine seeing a guy stab a woman to death and then run into a building. Her screams during the attack had alerted a police officer who gets there just as the door shuts behind the fleeing murderer. You tell the officer, hey, I saw the guy that stabbed her. He just ran into that building. Then the officer says, hey, thanks. I'll be back in about 8 weeks after we convene a grand jury and get an indictment. It's just not how it works. Now, I'm not going to say, of course, that the DA wouldn't prefer a grand jury over this preliminary hearing that was coming up, where both sides would be arguing. Because in a preliminary hearing, it's opposed in court. You can put the witnesses through cross-examination, adversarial process, and it's really just a probable cause hearing. So it seems like a lot to do just to get through that. And you see why the defense wants it, because they want to see what the case the prosecution has. And you can see why the prosecution doesn't want to deal with it, because if they have probable cause, they want to move on with the case in chief. But if you think there's any chance they don't have probable cause to proceed here, you're just a stamp away from sending Kohberger a message about how much you love him. It's crazy. It's probable cause, people, not guilt. Probable cause. Now, weirdos who say things like that, they're also pouring through the discovery fight paperwork to see patterns that show there's no case. This is a frame up. I mean, if you don't know what you're reading and you're just going to see what you want to see, why not go outside and look up at the clouds for shapes and patterns? It'll have the same accuracy, and it's healthier than reading a computer screen in a basement. For example, the state contesting turning over the genealogical DNA stuff. And I can see them losing that, by the way. It means, oh my God, the sheath is out. DNA is out. Right. Let's ignore that when they did that, they did not have Kohberger's personal identified DNA to test against the DNA that was found on the sheath, but now they do. What do you think that test shows? Kohberger's personal DNA against what was found on the sheath. And why might that make the more general family match, which the state says obviously is not exculpatory, not relevant anymore? Can you piece that one together? Come up out of the basement and go outside and look up at a cloud and imagine that cloud is Kohberger's DNA. Now imagine a cloud that is identical in every single way, and imagine that is the sheath DNA. And then come on back down to the basement and do some more noodling on that one. Well, the indictment hearing is coming next week. Kohberger's going to plead not guilty. That's no surprise, and that's fine. So it shouldn't be a very exciting event. But the court is ready and has issued an order and even this color map suitable for framing that you can use as a handy parking guide if you want to attend. So the final thing I'll hit about this is the order to seal the grand jury witnesses. The state says, in support, the state respectfully represents to the court that it has received numerous complaints from potential or prospective witnesses or their families and associates regarding being harassed both in person and via social media. The reports of harassment have included threats as well as what appears to be intimidation. Given this and the broad publicity surrounding these proceedings, the state respectfully submits that releasing their names would invite additional harassment, intimidation, and threats, and would undermine not only the integrity of this case, but the parties' prospective rights to a fair trial with an impartial jury. Oh my God, this kind of secrecy is so unfair to Kohberger. Hello, Cat of Justice. I don't know if you can hear it or not, but he wants to get in here, but it's not going to happen right now. Sorry. Oh my God, the secrecy is so unfair to Kohberger. Oops, there's a page 2 where the state discussed this with Kohberger's lawyer, who had no objection. I've said over and over the default state should be openness and opposition to gag orders and sealing things. It's not good generally. And I've also said, though, of course, being a lawyer, I know this, the courts can do those things in limited situations within certain legal limits. While I thought early on the secrecy in this case was overwrought, even though the state and Kohberger wanted it, I'm starting to come around to their side. It is completely credible that witnesses have reported being harassed directly or by having their families harassed or threatened. The purpose of open court proceedings is not to make witnesses targets of threats, defamation, unhinged conspiracy theories, or harassment by absolute lunatics. And if you take a look at just a tiny sampling of what is said, let's say about the surviving roommates in this case, it'd be hard to say it isn't happening, especially when the witnesses say it is. But what if they're all lying? I mean, I've put off for a while myself talking about the Delphi case because the last video attracted a bizarre collection of people making absolutely ridiculous and in some cases vile accusations against family members and even the girls themselves. I mean, it's one thing to think Alan is innocent, say, or the case against him is weak, say. It's fair. You could have good points for that. But it's another to support that by making unhinged accusations against people who have the misfortune to be actually associated with the case, either simply because they're family or they were around the area at some other time of the day, and that's all. So, as I've said a couple of times, there's not going to be no gag order in the Kohberger case. The media may get it modified. I can see that. But the court will be sensitive to issues regarding a fair trial for both sides and trying to keep the absolute circus of social media from infecting that. That's long enough for this week, I think. As always, I appreciate the thoughtful comments from you guys. And thoughtful is not a synonym for agreeing with me or not having a different take. Most of the stuff I'm talking about when I rage out on this are comments on other videos or things on Twitter or whatever. When someone's completely bonkers here and they make insane allegations against people that they invariably do not back up when I ask them to, I just send them to the ether. So if you see that and you don't see it later, you know why, or maybe you were a beneficiary of having missed that garbage altogether. Well, that's it. Thanks. Bye.